116 of your lordship judge list.
116.
But it has been fixed as for order because similar matter. Your lordship passed the judgment. And he carried that to the Honorable Supreme Court. The Supreme Court clarified the same. So I am paying for at this stage for same order subject to result of the appeal. Your lordship, this is the order passed by your lordship. Operative part, your lordship granted the entire period. They have restricted to 10 years counting at this stage.
What was our direction?
That's but one page, people directions.
Oh, but this is a
Yes, interlocutory order, but I am paying for at this stage same order so that I can survive. My client can survive at this stage. And in this matter, they pleaded that since the temporary or casual worker is there, I am not entitled. But in the Supreme Court, they have admitted.
So
Mr. Mukherjee, Kapon Mukherjee is appearing. Let
so
there
basically it's covered by Nimai Sir.
Yesterday,
This
same another matter in the month of December, same order. has been
this
passed.
judgment because they agreed that they will pay minimum qualifying. Therefore, the apex court has said we'll look into the other aspects
Correct.
because we had awarded interest also in there was excess. So there is no change from Nimai Chand Chatterjee.
Same. And another matter also following the Nimai Chand Lordship directed, they carried to the Supreme Court. Supreme Court viewed same in the same. Just now I am placing.
So this is a fresh case.
Yes, this is a fresh case, similar matter in the same list.
So it will come under the motion matters after 1 week.
After
1 116. 116. Yes. No, it is coming for the first time. So why it is not under motion matters? Acha. It is coming for the first time. It should come under the motion matters.
Subject to correction. Lordship already fixed the matter for orders. Let it come under the for orders for passing the interim order.
It will come under motion matters at the top.
At the top. Grateful. Well, I am intimating Mr. Mukherjee.
The other motion matters, it will be listed along with the motion matters.
Obliged, your lords. Obliged. And I shall bring another one. Obliged. Stop it. And I shall bring another order of the Supreme Court. Yesterday I was searching the Supreme Court's lordship judgment to the Supreme Court. I got that order itself also.
That also there is some
same issue. In December, it is in January. Right. I shall bring that also. Grateful.
I have your lordship's kind leave to mention, my lord, one hearing matter under Group 6 related to pension.
What do you want?
Inclusion.
Yes, inclusions all of you may give, please. All the matters which are required to be included will be included. Yes.
May I please one restoration application?
Give.
Obliged.
Yours is for what is that? Last one?
Lordship.
$49. What do you want? No. Wait. Yes, call the list.
Lordship, may I be allowed to mention one review matter, Lordship? The matter was dismissed. The WPST was dismissed, Lordship, in the last year. Now, urgency is that, Lordship, the petitioners is the candidate who qualified all the stages. But the
what is your application for?
Review application, Lordship. That
it will come in the next month. You give the slip. February listed on 2nd.
Item number 1,
Item number 1, Mr. Partho Chaudhary Das is appearing. He's before court number 8, my lord. I'm only praying for short passover, my lord.
You start, he will come.
My lord, the petitioner was appointed as the assistant sub-engineer, PWD, my lord, in the year 2000. My lord, that is at page number 39 of my petition, my lord.
Yes, so
My lord, thereafter, after working for 12 years, my lord, he had resigned in the year 2012. My lord, giving 1 month notice, he has given his resignation, my lord. My lord, thereafter, he had written several representation to the authorities, my lord, to release his legitimate dues, my lord, but the authorities have not considered his representation and it is still pending with the authorities, my lord.
you made any
Yes, my
representation?
lord. The last representation was made on 9th December 2024, my lord. It was by hand, my lord.
Which page?
My lord, it begins at, my lord, page. My lord, page 66 of my petition, my lord.
You have issued at least 10 letters. There is no order relieving you. what will you get? After 2012, you are absconding.
Well, thereafter, a written representation, my
That's what we are saying. You have been writing 10 letters every month, every year that give me my dues, give me my dues. They are asking you to go and relieve, get relieved. You are not going anywhere. What you will get? What will you get? This is the way for a public servant to behave. From 2012, you have not been performing your duties. Now it is 12 years. No, from 12 he is absent. Yes. And every time you say, I have resigned, give me my dues. There is no order accepting your resignation.
man, there is, my lord. Kindly takes up, my lord, the page number 55, my
What does it say? Read.
lord. It is a written, it is written by Executive Engineer, National Highway Division, to the petitioner, my
What
lord.
does it say, sir? Read the body.
It refers to the subject, and reference is to inform him that his resignation from the post of sub-engineer civil has been accepted by the competent authority of PWD Directorate with effect from final release from the present place of posting. It is therefore requested that he should join his duty immediately and
Yes, exactly. That's why we wanted you to read. This is not as per your wish that you will throw a letter and just go by yourself. Whether there are departmental dues, whether you have committed any misconduct, what are the things when you leave that place of posting, you are not submitting your joining, you are not taking a release. What can you get? You cannot get anything. It is unauthorized absence, obviously, for more than a decade. Which rule says that you give a letter and you go for all times to come? You cannot get anything in this circumstance. Yes, you are appearing. Yes. Why you have never complied with this letter of
Rejoining lordship.
14/5/2014, page 56. After all, you are a government servant, you are serving the public. There is no unilateral right to do whatever you want and without complying with the requirements, without challenging the order, nothing. All unilateral.
But lordship, there was no such proceedings pending against me, lordship.
Who knows?
Lordship, they have already
Where have they said that there is no proceeding pending? Show us.
as per their release order, lordship, the
Come
acceptance
to
of
page
the
56. Come to page 56. Don't just make submissions. There is a document which has been placed. There are facts also before submissions are made. The fact is that you submitted a letter and after that you are not doing any duty. At some point of time, they communicated that we accept it, but please go and join and get yourself relieved. You don't do it. What will you get? You tell us. What is the law?
But lordship, once the resignation has accepted, lordship, am I able to?
Then be happy. Then why are you here?
They are not disbursing my
You have not complied.
dues, lordship.
It's a contingent order. It is clearer than daylight.
Then your lordship's direct grant me leave to rejoin and direct them to.
Why do you need leave? You go and join. Who is stopping you? They have been asking you. Once
On
you
that-
join, now an issue will arise that from 14 to 25, what is to be done with you?
Then on that occasion, if I rejoin in the service, my resignation has already been.
You may think whatever you want, but the things will go by the rules. There is an acceptance communicated subject to certain things being done which you have never done. Now, what they will do, they know. That's not an issue. That is in the realm of a future thing which is yet to take place.
Then only to get my dues, lordship.
We know you are only interested in getting your dues. That we know. But whether you can get it without complying with the formalities, that is the thing. And now when you go after 11 years, how they will treat these 11 years, we don't know. It is your self-created circumstance. Obviously, you have no interest in the service. You are just interested in getting some money, nothing else.
For the providing of service of 12 years, Lordship.
Hmm?
I have already rendered service since 2000 to 2012, Lordship.
That does not vest any right in you to just leave the job whenever you want.
Lordship.
You are serving the public. You are an engineer. This is what you do. We don't know why you have fled away, whether you have committed some misconduct, whether there is anything we don't know. There may be nothing.
You can provide a report in this regard, Lordship. Otherwise,
What is to be done? There is no claim arising on the basis of the writ petition.
otherwise, my Lordship, the
There is no enforceable claim for which a writ. What is the direction we can issue? When you have not complied with the requirement, then what is the direction which can be issued? See, there is a voluntary resignation, a retirement, and there is a resignation. You have adopted the resignation. Resignation is not that you will throw a resignation and go. They will have to examine what are the dues, whether your records are clean, vigilance, clearance, this and that. There are so many things. And you are absconding. And now you say, give me dues. Wonderful. You have never complied with anything and you want dues.
I've already gone through the judgment passed by your Lordships,
Yes.
which I annexed, Lordship. But the circumstances is different. They have stated that there are some compelling circumstances that they want to join other sector in that judgment. But
See,
my
there is
difficulty
nobody
is that-
can be compelled to perform their duties if they don't want to do their job. But you cannot leave the job unilaterally and claim dues. The two are two different things. You could have approached this court that why they are not accepting my resignation. You want to take advantage of this long period. Now you will say, give me dues till 25. They will never give you. No court will ever direct. Whether they'll give you up to 14 or not, we don't know. Whether now misconduct has occurred because you have abandoned your service without complying with the
that
requirement.
Lordship kindly direct them to file a report. If your Lordships will not
You
satisfy,
pursue
they will
your
abide by
application. You
your
pursue
Lordship.
your application. They will take a decision, whatever decision they want to take. Yes, what is the latest position? Yes, continuously for 13 years. Correct. Not maintainable. It is not maintainable. Even before the tribunal, it was not maintainable. Before this court, also, it is a belated claim. How can you do this? Cannot be. Law is very well settled.
The cause of
There is
action-
no compliance with this letter of 14,514. Then no claim would arise whatsoever. Merely by issuing letter after letter, that will not do anything, will not cut any ice. Who is the competent authority to take a decision?
Pointing of it is that Lordship.
The executive engineer.
Executive.
Hmm. Which is the last letter which you have requested for release?
My last representation is 9th of December 2024.
December?
9th of December 24. It's 66 of March.
Page?
66 onwards, Lordship. The same data has been forwarded to the previous authority.
So you take a decision, who will be the competent person, chief engineer or executive engineer? So who should be the competent person to take a decision? The last letter is addressed to the chief engineer. Page 101. Who is his disciplinary authority? State government. So let the chief engineer decide. It is the case of the applicant writ petitioner.
Item number 2.
I appear for the status.
But I appear for the petitioner. Matter relates to resignation, but my lord, I may be candid, my lord. Today I unfortunately missed the brief. My junior who is there, affidavit of service and everything is with him. This is the predicament I'm facing. Your lordship, if it's tomorrow, my lord, I don't have an issue with this.
No, when are these matters listed?
This matter, yes.
Today other matters are there.
Matters are there in the list.
Same issue, my lord. Resignation of a doctor, my lord, they are seeking nothing, even except GIF and GIF.
No, on one day we have fixed all the matters.
Today itself.
Today
13.
itself.
These are matters are there, my lord. That is the reason, my lord.
I am appearing 2-3 matters. Their instruction is to appraise your lordship that subject to vigilance clearance, they will be relieved. They will be relieved of their accepted.
Let that, yes, obviously, vigilance clearance with you.
In which all 3 matters?
No, other matters are, I think, in 3 matters I have got the instruction. But in this present item 2 is concerned, this he resigned in 2009, 2010. So after about 15 years. So I don't know, I will have to take instruction in this matter.
Oh, in this the resignation is of an earlier time.
Earlier,
Yes,
date, my lord,
2010.
followed by a further reminder in the year 2015, my lord. No proceeding has been initiated against me. Nothing of that sort. Let my learned senior friend take instruction, my lord.
In this one, let him take instruction.
As much.
Yes. The learned.
So this matter, lordship, I'll take up the other.
Yes, we are one by one. One by
One.
Oh, it is not it is not one after the other.
No, my lord.
What are the serial numbers?
My lord, it starts from 29. 29.
Let's take it up. Yes, since it is, it will.
Item number 29.
ওটাকে বার করবে কথাগুলো আছে স্যার কোনটা থেকে
Yes, Dr. Himadri Shekhar Bala.
that is 29, my lord.
But there has been substantial progress in recruitment of new doctors. There has been substantial progress. And in the meantime, the instruction is very clear. That subject to obtaining vigilance clearance.
In all the cases, the order is similar. It has to be subject to vigilance. Let us.
Sir, I'm not disputing that. If there is like something.
This is the instruction anyway.
সীমান্তিবাদে স্যার আছে তারপরে আছেন
আস্তে আস্তে 31
অনিন্দ কুমার রায়টা কি করতে অনিন্দ কুমার রায় অনিন্দ কুমার রায় শেখর বালাই
Yes, it can be, need not be kept pending.
Absolutely, my lord.
But how much time the vigilance will take?
They have said that the entire process may take 3 to 4 months.
My lord, in earlier order, my lord, your lordship has passed 4 weeks, my lord. Let that be 4 weeks, my lord.
The lordship kindly see the
I will be
instruction
prepared.
is necessary
We have seen the last line.
Yes.
So first you keep the resignation pending for 6-7 months and then you say 4 months is more required.
It is the formalities, my lord, lordship.
Do it within 4 weeks. 4 weeks is more than enough. What is to be done? If there is something against him, you proceed.
So, my lord, steps have already been taken
Uh.
for vigilance clearance from the end of the director of medical education. That is also the beginning of last second paragraph.
Correct. So that means you have initiated, but you are awaiting the clearance. The sum and substance of the stand is that clearance is awaited. So either you proceed against him if there is something, or then you let him go. Why it should take 3-4 months?
No, well, that's I subject was the last occasion. Well, the recruitment of new doctors is on.
That
So
is now.
there has been substantial progress. Well,
No,
that's
no.
the-
Now that plea is over because the competent authority has accepted. This is in writing.
Yes,
So now that plea is over.
Yes, that's it.
That stage is over now.
So, well,
Now it is only vigilance clearance, nothing else. The competent authority has accepted the resignation with effect from such and such date. Everything is over.
Yes.
Now it is only vigilance, whether there is anything to be done against him or not. So be reasonable. 3-4 months is not reasonable. We have been directing 4 weeks in all the.
Lordship gives reasonable time. So
In
that
other matters, we have given 4 weeks. We want to maintain consistency. Will not be inconsistent. So this is, but the vigilance is not a party.
4 weeks or as soon as no. Vigilance not a
But this is the
or as
internal
soon as the
vigilance, my lord.
vigilance
So I
clearance
will not-
is
Oh, it's internal vigilance.
Internal vigilance, my lord. So I'm
My
not
lord,
the
the
party, the competent.
4 weeks.
What does it say? State Vigilance Commission.
Lordship. Subject to obtaining integrity clearance to be issued by the State Vigilance Commission.
But I have
Same
not
be
made,
issued
I
by
do
the
not know, my
vigilance-
lord, that I have to go to State Vigilance Commission, my lord. I have made the prayer before my appointing authority.
The Vigilance
and
Commission.
the person who can release me.
First of all, by the Vigilance Commission, and then the Vigilance branch of the
Health and Family Welfare Department.
And then this process, it takes for some time.
No, 4 months is. It is taking
bargain with the court.
It is taking a very casual approach to the whole issue.
Or if lawsuit there's 4 weeks or as soon as the vigilance clearance is available.
No. As soon as means as late as 2 years also.
No, I'm not.
We are not falling in those jugglery of words. Yes.
No, but then I'll
One month is good. Yes, we have been communicated. Yes, the OA number.
OA number is my lord.
Which is the next one?
32, my lord, my senior friend is able to
31, 31,
respondents.
32
Same issue.
Malati,
They would select it out.
32 Malati, same order may be passed.
Let us see the instruction.
Instruction word,
Because the dates and post and everything will differ. We don't want.
yes, but the way number will be different also. The same instruction, but Malati, that's not immediately available with me, Malad. I can't produce, Malad, but same instruction is there. I have seen that.
Let us see the last one.
Yes.
So he is from which post, in which hospital?
My lord, he is in Singapore Medical College Hospital. He is not an associate professor.
And the date is same,
Yes, Malad, the instruction date is same.
7/1/2026.
Assistant professor of Department of General Medicine, Singapore Medical College and Hospital.
Assistant professor.
My lord, Department of General Medicine, Singapore Medical College and Hospital.
And what is the date of resignation?
Date of resignation. I've taken 31 January 2025.
With effect from?
Except from the same day, my lord. My lord, with immediate effect. My lord, I will forego my salary for 3 weeks.
No, late item 31. It will be taken up tomorrow as we mentioned the instruction. This instruction is not with me.
31, and which is the other one?
32, you have to take up 32. 31, my lord, is a bishop of the Bushmoli was appearing for the respondent. Now,
That I'll appear. That's not.
So 31 and 32.
This matter, my lord, in this matter, my lord, senior.
No, let him come with the instruction. We will, otherwise, you know. if there is-
Regional letter date and my way number, there will be some changes. That's what I'm saying, my lord. But my lord, 46 can be taken. I've got the instruction.
No, 31, 32, you don't have the instructions.
Instruction, but not readily available with me.
Correct. So to right now, you don't have it.
Yes.
So 31 and 32 will just, not today, when it is taken up. Which is there any other one in which both of you?
It is 46.
You are in 46.
He's in 46. That matter be taken up. It will be.
What to call me, to call me.
46. 46.
File.
The Dr. Quail Mitramala, the resignation letter is 12th of February 2025.
46 file. She was associate professor of Department of Anesthesiology.
31, 32, Calcutta, 30.
No.
Dr. Quail Mitra.
All right. So we'll just.
Item number 3.
Item number 3, I'm for the petition, madam. I'm praying for not today, madam.
Hmm?
Praying for not today, my lord.
Why, sir?
My senior advocate engaging in Supreme Court matter, my lord, go for the Supreme Court matter. My senior advocate go for the Supreme Court matter, my lord. That's the reason. And the matter is under the heading of new motion, my lord.
Not today. Call the next.
Grateful, my lord.
Item number 4.
The item I appear for the petitioner. Service. My lord, matter relates to, my lord, a doctor, a dentist. My lord, initially, my lord, appointed, my lord, after his appointment, my lord, he was implicated in a criminal case.
He was
Implicated in a criminal case
after appointment.
after appointment, my lord, under section 376D of the IPC. Now, my lord, what has happened, my lord? As because I was being implicated and was taken into custody in terms of Rule 7.3 of the CCA rules, my lord, I was in custody for more than 48 years, my lord, 48 hours. My lord, I was placed under suspension once I come back. My lord, thereafter they issued a charge memo on 2 grounds. One is, my lord, I have suppressed one thing in 2009, one criminal case. The other one is this one. Now, my lord, in the criminal case in which I was being implicated, it, my lord, came to the investigating officer, filed an FRT before the learned court. My lord, an RG petition was also filed by the complainant. That was not accepted by the honorable court. And my lord, ultimately, I am being, my lord, acquitted from the criminal case. I am discharged from the criminal case. Now, my lord, that was also brought to the notice. My lord, nothing happened. And with regard to the other matter is concerned, my lord, which is of 2009, my lord, my name was not in the FIR. Nothing was done. On the contrary, my lord, the police verification role which I have filed, in terms of that, the internal security branch of the Home Department made a detailed inquiry and found, my lord, I am suitable for employment. This being the situation after the criminal case is over, the internal security branch came to a conclusion that I am suitable for employment in government of West Bengal. That is in 2020. Still date, my lord, neither the suspension has been revoked, nor I am allowed to join, neither the proceeding which is there, purported proceeding, for which already the criminal court come to a finding I am not been guilty. My lord, that is not been concluded and I am suffering, my lord. If your lordship takes up one by one, I am pressing, my lord. If your lordship takes up, my lord, my suspension order is page 46.
What is the date of the suspension order?
My suspension is of 15th of July 2019.
So you are getting 100% subsistence
No, my lord.
allowance.
Initially, I was getting nothing, and now 50% I'm being paid. Although the rule says, my lord, it should have been enhanced to 75%, and thereafter further enhancement is there. And also, my lord, there is your lordship knows, your lordship passed an order, my lord. In terms of the government circular, there should be a review, periodical review. Nothing was done, my lord. My lord, your lordship will find page 46. This is the suspension order. It says, my lord, such and such Dr. Mutiur Rahman, dental surgeon, Bamangola Rural Hospital, Malda, was arrested by police on 13/10/2017 in connection with English Bazar woman PS case number such and such, under section such and detained in custody till his release on 26/10/2017 on bail. And whereas Dr. Mutiur Rahman was detained in custody for a period exceeding 48 hours, and whereas said Dr. Mutiur Rahman was arrested in a criminal charge involving moral turpitude on his part, and whereas the governor is appointing authority in respect of the post held by Dr. Mutiur Rahman, now therefore in exercise of power conferred under sub-rule 3 of Rule 7 of West Bengal Services Classification Control Appeal Rule 71, the governor is pleased to hereby place Dr. Mutiur Rahman under suspension with effect from date of his detention, i.e. from 13/10/17.
No, but they are paying you half the subsistence.
No, initially they were not paying. I made several representation, but your lordship will find thereafter one memorandum was issued. Charges. That is page 48. There are two charges. This is dated, my lord. Dates are important, my lord. Your lordship will find the memorandum was signed on 4th of, at the bottom, my lord, 4th of September 2019. Lordship has got it, my lord. 19. 4th of September 2019. At the bottom. Well, there are two charges which they have given in the imputation. Well, page 50, your lordship will take the.
Where is your reply, written statement? Where is your response to the charge memo?
No, it's not been annexed here. I'm just saying, my lord, I'm on suspension.
When have you given it? Where have you stated? When did you respond to the charge memo? Where is your statement?
My lord, that is not the issue, my lord. Here, I'm just saying, my lord, if they can get it, anything. My lord, it's not there, not in this application, my lord.
No, have you said that you responded?
Lord, I have attended twice, that I have said. I've attended twice, my lord. In the representation is mentioned. I've attended twice before the Vigilance Authority, who is now conducting the inquiry.
Where is that?
I'm coming, my lord. If the lordship takes up page 75, well, there are other letters also there. The lordship takes up page 75, penultimate paragraph. Again, my lord, it starts from again. as per memo number such and such, West Bengal, the IA was appointed cancelling the previous departmental order, I number such and such of the Deputy Secretary Government of West Bengal. It may be kindly noted that only 2 hearings of the departmental proceeding took place on such and such respectively, but the outcome of the said proceeding is yet to be received by me.
No, you don't say you appeared. Neither you say you appeared, nor you say you have responded. If it is being, there is no progress because you are not cooperating, then what is to be done?
But thereafter, my lord, nothing, my lord, no notice hearing was issued to me. But these 2 days.
Where is this statement that no notice?
I understand, but I understand your lordship is what your lordship is saying. My lord. What I'm now at this stage, my lord, is this: I'm not on proceeding. Let the proceeding, whatever they take, they take. My lord, with regard to the suspension part, my suspension was there in connection of a English Bazaar Women's Space PS case. Now your lordship sees this order of the criminal court.
No, see, the subsistence allowance does not hinge on findings in the criminal proceeding. The subsistence allowance hinges on the outcome of the departmental proceeding or continuance of the same. It has nothing to do with the criminal proceeding. So if the continuance is not for your lapse or because you have not cooperated, then there is a provision that it has to be revised and a decision has to be taken with reference to the records. If you are not appearing, if you are not responding and they are not able to proceed, then what is to be done? You are getting some subsistence allowance. If you are happy with that, stay with that.
Only thing, subject kindly, my lord, I may be wrong. My lord, I was placed under suspension under 7(3), which says in connection with the criminal case I have been arrested. That says, my lord, as because I was arrested in connection with any criminal case and I was there in custody for more than 48 hours, that is the only reason of putting me under suspension.
No, your suspension is 2 years thereafter. It is in 19.
Yes, Lord, but they have put me under suspension. If your lordship takes up
that must have been revoked automatically.
No, my lord, it's still not has been revoked. My lord,
how we cannot reconcile with this submission? You please see the 19 order. It is from the date of the order. It is not from a prior date.
My lord, your lordship is suspension or page 40.
Now, therefore, in exercise of 3(7), this is of July 17.
This is with the retrospective effect.
We are placing you under suspension with effect from the date of his detention. That is correct.
17 with retrospectivity.
So, but this you have never challenged. This you have never challenged.
But this suspension order, my lord, in my contention, subject to kindly, as because I was placed under suspension in connection with this criminal case, where the IA comes to a finding, my lord, I am discharged, and the honorable court accepts it. No, my lord, then there is nothing alleged against me. And my lord, I may say, my lord, state has not preferred any appeal whatsoever against that. That order of the learned CGM, my lord, has reached its finality. But if that been so, my lord, your lordship takes up the report of the, my lord, the FRT report. My lord, your lordship takes up, my lord, page 56. My lord, this is the order passed by the learned CGM, Malda. My lord, in GR case number 2330 of 2016, my lord, there the FRT report is also there. My lord, your lordship will find last 3 paragraphs, the learned lawyer of the accused person submits that the de facto complaint already filed one affidavit dated 15/10/17 before the learned court with submitting that she filed this case against the accused person under pressure of the villagers. He also further admitted in the affidavit that the incident of rape did not take place at the time of incident. So, considering the submission of both sides and after going through the materials on record, the FRT filed by the investigating officer hereby accepted at this stage, and the Naraji petition is hereby rejected. So, my lord, this order where the Naraji petition was filed, my lord, that was rejected by the learned CGM. Now, your lordship takes up the next page, my lord, that's the FRT report. If your lordship takes up page 50,
that is not our concern. We have nothing to do with that. In these proceedings, we have nothing to do with that.
Now, my lord, your lordship will find after that, my lord, whatever the charges are there, my lord, the government in 2020 says I'm suitable. So, my lord, either I'm my lord, not suitable for employment as because the proceedings are pending, which says, my lord, that I've been implicated in 2009 and this case, which has come to a finding of FRT. On the other hand, my lord, the government himself says, my lord, I'm suitable in 2020.
The problem is you have included two relief. We don't know how you could have done it before the tribunal. Two distinct cause of actions you have
I will be
merged in one case.
I will be confining your lordship with absolute right, my lord. There can be plural remedy in tribunal.
How can you do this?
I will be confining myself to immediate suspension. Let the authorities take a decision on my suspension, as because, my lord, there is a government circular, and that has been stated, my lord. There is a government circular of the government which says, my lord, after 90 days, my lord, the suspension is to be reviewed, and for every 6 months, every 3 months thereafter, it is to be done. My lord, nothing is done in my case, my lord. Let them at least take that call.
Yes, take down.
Item number 5.
এটা কি রে? এই বিরো-
Lord,
Where is your application for change of nomination? Where is the representation for change of nomination?
My lord, before that, may I submit one thing? The petition, the petitioner has expired on 9th of this month. My lord, she will be, as per as the instruction from her sister, who was the attorney. My lord, she will be, her name will be substituted, my lord. But till then, my lord, praying for some time to do file the substitution petition, my lord.
The learned advocate informed.
After 2 weeks.
Sister will be substituted. Sister.
Item number 6.
Item 6, my lord, I appeal for the petitioner. My lord, this is also resignation of a doctor. Now, your lordship has clarified in your lordship's order dated 9/12/2025 without any uncertainty. There is no ambiguity, my lord. My learned senior friend is to produce the order.
So in this, it has not been accepted.
No, my lord. Still it's pending, my lord. Even after your lordship's order, your lordship has quoted your lordship's judgment.
Today, in 3 cases, they have come out with order that yes, we have accepted. Why?
well, in other matters, we have given an objection.
No, this is not no objection.
No, resignation, accepted resignation. Department informed me that because of the OBC judgment,
selection process stalled. Now we are taking steps to appoint the doctors. Give me some time so that we can solve the problem.
Today, that's very some person who is giving you this instruction. He gave instruction to the learned GP that we have accepted the resignation. 3 cases they have communicated. What kind of left hand doesn't know what the right hand is doing?
That's the information.
Today we have taken it on record, the orders that we are accepting it.
Your Lordship can pass that order directing the government to.
No, sir. Then you please address as per the last order. You go through the last order of the court.
Yes, 9th December
Yes,
2025.
you come to paragraph 3. Where are the other 3 cases today in which they have communicated a contrary instruction, and in this they are communicating a contrary instruction? Let us see. In whichever case they want, they will come submit any kind of instruction. Very wonderful.
Item number 46, Dr. Koel Mitro.
No, first it was 29.
Yes, Dr. Himadri Shekhar Bala.
29 and then 32.
32, my lord, your lordship fix it tomorrow.
29.
46.
46 in both cases. In both the cases, they have given instruction that we are accepting subject to vigilance clearance, and in this case, they are giving you instruction that the proceeding is going on for appointment.
No, proceeding for recruitment of
Yes,
health officer.
yes. That is what they had submitted in that case also on the earlier occasion. That recruitment is in process, we will accept. In that, we have said that now we have accepted. They are all doctors.
No, certainly, my doctor. If that instruction is that.
You please see, you ask the learned GP, he was here. Mr. Datta, he has come with the instruction. We have taken it on record.
When I had a talk with Mr. Dotto, he will not the same facility will be available to the expedition also, because all the persons who are tender designations, government.
Sir, it will come on Monday, not today only.
It's Monday instead of stop. Let this be a top, my lord.
Let it come. It will come in the motion matters.
Instead of Monday, can make it a Tuesday.
No, sir. What is this? This is too much.
19th, I have some difficulty.
All right. As prayed by learned.
Item number 7.
Even I am
Motion matters, madam. Adjourn motion, adjourn motion.
But I am appearing for the petition. So there was a direction.
7.
Yes.
What was the direction?
There was a direction, my lord, to file affidavit in opposition, my lord. Then the time was extended. I think my learned senior friend has some difficulties.
The difficulty is that, my lord, may I tell one thing? Very frankly, Lordship, the 2010 writ petition was filed, 2010. Now, my lord, the matter, the incidents happened in 2001 and then 2002 and then 2007. The incident is that, my lord, the inquiry was made, initial preliminary inquiry, 2001. Then on the basis of that, my lord, the departmental inquiry proceeded or started only in 2007. Then, my lord, the writ petition filed that why such delay and other thing. Then, my lord, there is a stay from this court with regard to departmental proceeding. Now, after that, my lord, I chased, my lord, not less than, my lord, 4 officers. But everybody is telling me that they are looking after the record and file, because the main thing what failed from your lordship on the last occasion, that why such delay? Why that after 6 or 7 years, you started the departmental proceeding and, my lord, slapped the so-called notices and all these things. Now, my lord, whatever instruction I received, though my lord, on the basis of my submission, it has been recorded. I received instruction on last. But after that, when my lord, gone through the instruction, it appears the instruction is nothing which I received. All the annexures annexed to the deed petition to the instruction. So that would not, my lord, they help me with regard to my lord, answer to that. So lordship, kindly give me my lord, another fortnight maximum. Let me see if I, my lord, fail to, then nothing can be done.
We give him one fortnight.
That is all right. It's only one difficulty I'm facing. Perhaps my learned senior friend doesn't know this fact, but in the meantime, there is one development. When 2010 this writ petition was filed, there was an interim order staying all further proceeding in respect of this disciplinary proceedings concerned. Now in 2023 or sometime in 2022, my lord, the erstwhile learned advocate on record left property. So thereafter the matter, my lord, dismissed for default. Then again it was restored, and all along this interim order was there. But when it was restored, my lord, perhaps, my lord, the interim order was vacated. So it stood vacated, my lord, at the time where it was dismissed for default. As on that
In 23.
23, then it was restored. Now today, the state is, my lord, seeking time, my lord, to file affidavit in opposition. But in the meantime, my lord, they appointed an inquiry officer, and my lord, the disciplinary proceeding. My
Well, I think it is not in my knowledge. And also, my lord, since my lord 2010 interim order, then so many things happened. So I think, lordship, that my lord, they will not proceed if your lordship pass an order, there is no difficulty. But even that interim order, copy of the order is not in the, with record of the department also.
No, but when it is restored, then normally it is.
Normal, yes, normal.
And when you lordship is seen of the
Yes,
entire.
but I have not, my lord. I do not want to stand in the
So what will happen in 2 weeks? There is some date.
So there will just, my lord, I am, my lord, it is my duty to.
No, if there is any date in between these 2 weeks.
In the meantime, my lord, if they, my lord, give me any date, my lord, a direct appointment, the inquiry officer may, my lord, direct me to appear before him in the meantime. That is why, my lord, this is my apprehension.
Where is that restoration order?
Not to proceed, good. This isn't over the matter. পরে আমাকে যে ব্রিফ এসছে
My lord, the 21st of November 2025 order. Can 3, the application for restoration in the middle, your lordship will find can 3 was allowed.
Yes. On
Now I appeal for the private respondent.
Private.
Private respondent. The private respondent number 1.
Lordship, this is my application, Lordship, in challenging an order of the administrative tribunal wherein I have been directed to grant promotion, pass an order in regard to promotion of the respondent number 1. Lordship, I am being led by Mr. Sengupta.
Yes.
Very short point involved. We are playing the role of the recommending authorities. When we are recommending authorities in the process of the selection process, the selection of the promotion, we have recommended 2 persons' name. Now I will show you a lot of the document. Respondent number 1 and respondent number 2. And we have the thing that yes, to select another person despite of the petitioner's case. Now challenging the same, they have came up before that. Now there we have categorically stated.
You are the employer. You are the employer.
It's not. Yes.
Employer recommended 2 persons. Commission selected a third.
No.
Among them.
One. Who is respondent
Now,
number 2
out
here?
of the 2, they have selected one other than the respective.
Now the challenge is for our case, Miller. I will just show to you a lot.
So what he approached the tribunal saying that he is the better candidate.
I tell you, maybe he has a better.
No, we are not asking you. What he approached the tribunal claiming to be the better candidate that he has wrongly been overlooked.
I tell you.
May I?
Disciplinary proceedings and other things is done. The learned tribunal did that we should issue below the promotional effect. And we cannot. Kindly take time to see the order.
Just let us see the order.
Right.
Page 77.
Oh. So there was no charge memo on the date of consideration by the DPC.
We are not on that. We are simply seated on the same point. The execution part of the military order. If this order has to be executed power, we are recommending of that will be considered by the PSC. Kindly take trouble to see.
And respondent number 4 was a party there.
Yes. Only thing was we are not fair. We have concluded our part.
This is promotion to which post?
Chief
Probational
officer.
Probationer.
Probational
Jails. In the jails.
Yes.
Correctional homes.
Yes.
Principal probationary officer.
Yes.
Here one is called Chief CPO.
Oh, CPO.
The probation comes after care officer. Normally, our trouble is that if you not see the order which is at page 8, then we cannot see the letter. Yes, we are the only recommending part.
So was PSC a party there?
Yes, PSC was party. No, your lordship takes up. I'm not saying anything. The lordship takes up on page 81. This is what they have sent to the PSC for the purpose of promotion. Lordship has got it on 81. Now, your lordship may turn over to my lord page 84, annexure 2. My lord, they have done this mischief. Now, my lord, they are saying the recommending authority in the PSC has not done so. Your lordship takes up page 84 once.
So they are not opposing the order on merits. They are saying it cannot be done by them.
Right, it has to be by them. They are the administrative authority. The PSC is a recommending authority. PSC's recommendation may be accepted.
We are just trying to understand their case. You are not opposing the order on merits.
I only we are saying that in order to execution of this order, we are not taking the appropriate authority. We are saying that the recommending part have done. This has been mirrored in the proper channel from the PSC. Accordingly, PSC.
So under the recruitment rule, what is the role of the state and the PSC?
Time takes travel to see page 61 once. I will
No, where is the recruitment rule we are asking you?
recruitment rules. This is
There is a direct recruitment also to chief probationer officer, only by way of promotion. So where is the rule? Where is the
Appointment.
Grant me some time, my lord. And I have annexed with the original application I can find. Whether they have any interest in that is it. But if you takes up page 29, my lord, I have in my original application I have annexed, my lord, it's a part of the original application. My lord, it says with regard to deputy chief probation come aftercare officer, but with regard to this chief probation come aftercare officer, my lord, I don't know anything, my lord. So let them produce.
your lordship. Take travel to immediate reply.
In the main.
This is the feeder post for which I am seeking promotion, my lord. That rule have annexed. Page 20.
We are trying to see what is the procedure. They are, if they are saying that there is a difficulty in execution, let us see the procedure.
I mean, I do not have writing this moment.
It is submitted by the learned state advocate that
One week. Could there be a Woody? Maybe to pass. Back to the
Item number 9.
Yes, who is for the commission? You are required to produce the result.
Have placed it on record, Milord. They have been served with the copy.
It's filed.
And you have a look at order dated 7th November, Milord. The matter was hard at length. The detailed order was passed. Milord.
Then only we have said that you have to place the result on record. Therefore, after that, when did you place the result on?
28.
You have filed an affidavit.
No, Milord.
Oh.
In November, Milord, the Lordship directed copies of the results were placed before your
What is the date of this result? Fifth January. Yes.
A very short question, and after all this disclosure, they have undertaken without shelter to 2017. The selection was initiated with that mark back. Therefore, they will not be qualification and other things which was available under 26 prior to 2017 should be followed. And that is the advertisement. Kindly come to page 108. Advertisement is that starts at page 105. It's done by the West Bengal Staff Selection Commission. And this advertisement would categorically states, kindly turn to page 108. Eligibility criteria and qualifications. Pass insurance, acquisition of elementary knowledge in computer operation with ability of typing on computer at the speed of 20 words per minute in English or 10 words per minute in Bukhari from a reputed organization for a period not less than 6 months. So this certificate was then necessary for the purpose of the permitting me to contest. Then the above noted qualification must be possessed by the candidate on or before the date of publication or advertisement. Therefore, these two certificates were necessary for the purpose of participation. Then note, after recruitment to the post of the lower division assistant or clerk, incumbent shall have to pass the examination of elementary knowledge and computer operation and computer typing. It will be conducted every year by the staff selection committee. The lower division assistant clerk will be unable to pass the examination and not be entitled to get increment. But after entry into my service on the basis of my eligibility, that if you want taking every year without one upgradation of your skill, you will not get the monetary benefit. But this cannot be without use for the purpose of the block of my road. Because on many they are submitting that my stands much higher than those others who have been given the appointment.
No, there appears to be an issue that you did not pass the typing test.
In terms of this note, I say that typing test would be necessary only after I am recruited. That is necessary for the purpose of my increment. That if you cannot develop your skill, you cannot get the monetary benefit. But eligibility criteria, as I have said.
And when did they introduce the typing test?
They say they have done it pursuant to 2017 Act.
What is the date on which they published the requirement?
Yes. This requirement was not published in their affidavit. They say at page 4. Yes, kindly come to the affidavit in opposition filed by the PSC. They have annexed the
Possible, Mr. Bhattacharya, to proceed like this. We need a paper. Yes, please. Everything is.
That we shall file information.
Yes. How soon can you do it? We'll take it up.
2 weeks. 2 weeks.
Formal paper to be filed. Or if there is something which needs translation, please do it.
Item number 10.
Lordship, I am appearing for the Public Service Commission on the last occasion after the hearing. Lordship directed to file the compilation of the judgments Ranvijay Singh, Mukesh Thakur, all which are filed. Lordship.
Not today will suffice. Tomorrow it will not come. Tomorrow it will not. It will now come on Monday or Tuesday. Next Monday.
Next Monday.
Grateful, my lord.
The learned advocate, you are for the commission. Madam, you are for
Appearing
the
for the
learned
Public Service
council.
Commission.
The learned council for the commission and the state are
Item number 11.
Lordship, I'm appearing for the petitioner. And
please use the mic, madam. Yes.
Your Lordship? Am I audible? Your Lordship? Your Lordship, I'm appearing on behalf of the petitioner. Your Lordship, I'm led by Mr. Kolul Basu. He's on his legs.
Not today. Call the next.
Item number 13.
Original, just like with my junior, my lord. And
Not
yes,
today. Not today.
I got the state.
Not today. Yes.
Lordship.
Item number 14.
It will come on the Monday. We have adjourned it not. This is
Declaration of.
oh.
Your Lordship has matters at the judgment with which this class, we have been watching it in the last 40 years. we have been- Mark by mark,
No, on the last day you were required to submit the translated copy.
Malra has submitted the translated copy for representation. I've submitted the representation, the last representation of considered by the authority law that I have been recommended submitted December already.
Oh.
Even order is the law, page 119 the law, passport the law. Order.
Two representations are there, on page 66 and another on page 76. Both the representations are printed. So you will not commanded is the competent authority. Yes, recommended 6 times for the evaluation of the petitioner in the vacancy.
Yes. Which are the two documents for which we had asked you to get the translation? Annexure D and G. Where is your initial engagement order? Your initial engagement order.
Page 46. Annexure A, my lord. Page 48. One for 2000 again. Not exceeding 2 weeks at a stage per month. Volunteer.
What is the basis for such volunteers to be appointed? Where is the provision? For civil defense volunteers, where is the provision? Where is the enabling provision?
Civic volunteers are appointed by executive order.
Under which provision? Where do they get the source of power to make such appointment? Under which provision?
And executive order. National Volunteer Force, there is Act. Home Guards Act, there is a statute. But civic volunteers only by executive order. This is a volunteers, civil defense, but not exceeding 2 weeks.
No, there is a government order of 28/12/2007.
Yes.
Where is that?
That has not been annexed.
What is the sanctity of such people? What is their status? How they are selected? What is the basis of their engagement?
Can you see the page?
The nomenclature suggests that they have volunteered to work.
Yes.
So therefore, we are asking you, where is that? Under which provision?
On a page 46, what about?
No, page 46 is nothing. We have seen 46, 47, 48. Therefore, we are asking you.
Your Lordship wanted to see.
So the commandant, whoever he feels like, he can ask him to come and start working.
No.
Then what is the provision? And then he will come and say, regularize me. What kind of a scheme is this? And others who are not, whose face is not to the liking of the commandant, they will stay on the road. Where is this government order?
Page 80, paragraph 10. Page 80, paragraph 8, reply before the paragraph.
No, you are not answering our question. You may have seen the executive order. You may have seen the executive order. I have not seen it.
I have not also.
So what kind of this arbitrary power has been vested in the commandant? Whoever he likes, he will ask him to come. And he will raise a claim for regularization. And the recruitment process is over.
That is 15th of October 2007. 15th October 2007. Subject to correction. Mentioned about 15th October 2007. I will bring that. Nothing.
See in 46, what he is saying, I am a volunteer, please take me as a driver. And commandant says, come. Wonderful.
But there is a circular issued by the government, 15th October 2007.
So if he wants, he can become driver. If he wants, he can become whatever he wants. Where is that provision? And then he has a claim for regularization also.
I'll bring that. Order. 15th October 2002.
There is no advertisement, there is no post, nothing is there. He says, look, I'm a volunteer, you take me as a driver. And he says, yes, come. We'll give you work for 2 weeks every month, you come, we'll pay you. Wonderful. State's money is being, the commandant has a decision to do it. Whoever he wants. Liberation comes later. We want to see how it is being done.
15th October 2007.
That's I don't know. We don't know. This 15th October is for the driver.
Driver.
How he became a civil defense volunteer. How he became a volunteer, under which provision we want to see. Everything starts from his becoming a volunteer. He says, I'm a volunteer, take me as a driver. See, page 46. Unique. We don't know if such a arbitrary power is vested in any commandant anywhere else. And such beneficiaries, whoever they feel like, they will come and say, take me, and they will say, come. They will pay from the state exchequer, and then they will say, regularize us. We don't know where is the process. We don't know which post he is working against. We don't know what is his qualification. Comes with a license, come, start working. Wonderful. The whole concept of regularization is founded on a regularization of an irregular.
Yes.
Look at this. What about irregular? We don't know anything about this person. He says, I'm a volunteer, engage me. Yes, you come. Now regularize. You have been working 2 weeks every month, regularize me. How he came, why others did not come, why were others not allowed to come? What was so special about him?
This 15th October 2007 circular would be very.
We don't think so, sir. That 15th October is only for driver.
There.
Prior to driver, he is a defense. Please see page 46.
He should be.
You see page 46.
He should be
I am
trained.
a civil defense volunteer. I have come to know that there is a need for driver. Please engage. Yes, yes, come. Yes, come. We'll give you work for 2 weeks every month, and then after 10 years, regularize.
There must be source of power.
Otherwise, how it is being done? How did he pay him for 10 years? That we are trying to see. Regularization will come later. Who gave him the discretion to do this? And how, under which provision? A larger issue
Item number 15.
Please comment.
All
17 and 18. I'm also.
14 to 18. 14 to 18. You are appearing in all.
17 and 18. 14, 17 and 18.
And who is in 14? So your all cases are represented, both sides.
I'm presenting all.
Please give the appearances.
আপনার কততে আছে আমাদেরটা হয়েছে 17-18 হ্যাঁ আমার পেয়ে গেছি 17-18
No advertisement, no procedure followed.
Item number 19.
In item number 19, led by Mr. Subhosei Chatterjee, he will appear virtually. On the last occasion, Your Lordship substantially heard the matter. The moot question involved in this matter, Your Lordship, that whether the OBC certificate that can be considered even after that can be considered even after closing date of the submission of the OBC notifications. That was the moot point of the Your Lordship.
He is appearing or he is not appearing? What are you saying? First tell us that.
Kindly keep this matter a short passover. Your
Not today. Call the next.
Item number 20.
Not today. Call the next.
21.
Twenty 21
Mr. Mukherjee, you are filing the opposition. Huh? Third extension will not grant, you file it. We are adjourning it not today. None appears for the writ petitioner. Matter stands adjourned for the day. Call the next case. What are you doing?
21
22.
Not today. Call the next.
23.
Pursuant to your lordship direction, my lord, I have filed by the as well as the supplementary.
Supplementary? No, we are not going to take any supplementary. You take it back. Give the reply. Yes.
Copy has been. Lord, this is for your lordship. Okay. That's good for it.
তাহলে কত তারিখ ওইটা দিয়ে যেটা তোমার 19 তারিখ 19th January সোমবার আর 12 সাথে 19 তারিখ পরে 21 22 মাত্রটা 23
Yes. Why 2 years delay? 2 years, 2 months? Who is for the AG Bengal? There is any provision in the statute for delayed payment of pensionary dues?
Section 11, subsection 3A of the Gratuity Act does not apply.
Payment of Gratuity Act will apply to you. What kind of submission you are making, sir? Payment of Gratuity Act will apply to you. Then why you are referring to Payment of Gratuity Act? We asked him, you said yes, as if you are going to point out some provision, and then you say Payment of Gratuity Act. We are asking you a factual issue. There cannot be two answers. There can only be one answer. Whether the DCRB contains any provision that if the pension payment is delayed, there is some dues to be, interest to be awarded. Under the DCRB, there is no provision. So if an authority decides not to pay the pension for 5 years, he can do it.
Because under the rules, pension rules, before retirement, at least 1 year before retirement, paper has to be submitted for processing the paper. Then, one month before retirement, he will be committed that he will retire on certificate. When he retired during the COVID period.
That is, so therefore, COVID period objection is irrelevant. It was required to be done 1 year before that.
No. 30th September, he retired on
2020. So it was required to be done much before that.
Until unless PPO is issued by the AG Bengal,
No, sir, we are asking you again. If an authority decides not to sanction the pension for 6 years,
that cannot be.
Why it cannot be? If there is no consequence under the DCRB, that can be. Unless there is a consequence, how you can say that it cannot be?
Only disciplinary proceedings pending or criminal case is pending, then some benefit can be withheld, nothing more.
That is a different thing. We are not on that. We are asking you whether there is any deterrent in the DCRB that if there is a delay, either some action is to be taken against the person who is delayed or some interest is to be paid. If not, then how you are saying it cannot be? Then it can be. The DCRB provides that it can be paid whenever they want.
No. As soon as the retirement takes place,
Where is that? Show us the provision.
পর্যন্ত এই ছিল কোভিড পিরিয়ডটা।
ভোট হয়েছে তো 21-এ মে মাসে ফেব্রুয়ারি 22 সালে দিচ্ছে, 21-এ ভোট হয়েছে জেনারেল ইলেকশন, ইলেকশন হয়ে গেল।
No, where is that provision? You said there is a requirement that 1 year prior to the retirement, it has to be prepared. Where is that requirement?
From continue for law. Because thereafter the general election was held.
There was suspension.
And it was submitted for the on 24 to 2020. And it is page 10 of the written opposition on behalf of the AGP members. Page 10. 14th October 1996 circular.
Respond number 1.
Corner number 2. Member. Page 10.
Page 10. Places. Official reply. Exclusive. Reply. So not no obligation. Question by number 1. The reply. The reply to our respond number 2. This is by respond number 1. There are two copies. Which chapter? Opposition of respondent number 2. You have been served with an opposition by respondent number 2.
That was DRC, my lord, before retirement, all papers have been submitted.
Have you been served with opposition of respondent number 2?
My lord, yes, I have filed the reply, my lord. Affidavit is reply. My lord, they have stated, my
Chapter
lord,
12 is at which page? Chapter 12 is at DCRB.
additionally. With 132 non-executive.
Rule 132.
After this has been issued, the direction shall be. Starting, what that means, if there is a delay, then action should be taken after some time.
Audit officer means from the West Bengal Accountant General. There is a liability. What was his date of retirement?
The 30th September 2020.
And pension paper was returned on 4th March 2021 from the given law.
He retired in 2020.
2020. During the COVID period.
So it was returned in March 21.
No. 4th March 2021, site was returned from the AG Bengal to the employer. Superintendent of Regional Hospital, Dolobia.
Then after that, it took him more than 1 year to start the pension.
Then after correction everything, then the pension payment was issued on
20th October 2020 and payment was
30th June 2020.
Dixon Hill Dixon Hill regular general election head.
Because he has overdrawn 1,29,633. On that, yes, overdrawn amount, certain amount.
and interest minor return of pension papers, no intimation said minor to be employed.
Election
So if the Accountant General takes all the time in the world, then there is no duty or obligation on the part of the employer.
No, but not only obligation, but not if my employee or state government employee delayed, then disciplinary action could be taken.
No, we are saying that you say that in June, you have sent the papers to the audit officer. So after that, you have to do nothing.
No, but then, Malad, they have said that there is a overdraw.
That is later. You have sent it in June. He has retired in September. So if it is lying with the audit officer, then you have no obligation.
Until unless it is sanctioned.
All right, we'll come back. You see Rule 137.
Near side, item number 1. I beg to appear on behalf of PROCEEDINGS.
Copy of paper book was directed, a copy of paper book has not been served.
Wait, yes. What is the case? Hey, Lord, you offered them, my lord.
You may have not received. Let us see what it is.
So this is relating to, my lord, the building.
As far as the corporation is concerned, we have received it at around 12.
All right, let us see.
Yes, your lord. Also, kindly see, my lord, the building plan, which is enclosed at page 26. Page 26, lordship. My lord, this is not building plan, my lord, actually for repairing roof under the provision of, my lord, the repairing, they have obtained this particular plan and they are doing construction merrily, and my lord, additional floor, roof, lift, everything. Our humble submission, my lord, this should come within the four corner and ambit of regular sanction building plan under section 390, not as, my lord, under rule 3. I may be allowed, my lord, to show at the very outset, my lord, the provision of the rule 3(2)(e). My lord, what is there? My lord, some things, my lord, whitewashing, flooring, and all these things can be done under rule 3(2). And my lord, only in case of a, my lord, damaged roof, if one intend to change it, in that case, my lord, rule 3(2)(e) is applicable. Taking advantage of this, my lord, lordship will find from page 26, my lord, may I hand over a copy, my lord, the original copy, Xerox of which, my lord, is with me. My lord, it is reduced, so far paper book is concerned. May I hand over this? দুটো আছে? এটা দিন না? Okay. আরেকটা? হ্যাঁ।
Yes.
May I show, my lord, the original plan? Lordship will find, my lord. Kindly see, my lord, the original plan, which has been reduced in the paper book. It would be difficult for the honorable court, my lord, to read it. I brought one copy.
The paper book.
Page 26 is, my lord, the plan we have enclosed.
Give the paper.
So-called plan, this is the repairing plan. Cannot be treated as, my lord, the regular sanction building plan. And it is a fit case for regular sanction building plan for additional floor, lift, stair, all this inserted under section 390 of the Kolkata Municipal Corporation Act. I will show, my lord.
Yes.
Before that, my lord, kindly see the plan itself, 26, page 26 I have enclosed. I'm just reading, my lord. The original is lying with the court, my lord. The reconstruction plan.
Where is the permission?
permission, that is a permission. Lordship will find they have taken permission under Rule 32E of Kolkata Municipal Corporation Building Rules 2009
For making repairs.
for making repair.
You are saying rather than making
Yes,
repairs, they are
yes.
undertaking a substantial construction.
Substantial construction is going on.
All right. Then,
Including in the common passage, they have inserted the lift.
all right. Then what is the consequence?
Well, the consequence as a result of which, my lord, this is for the meant for the section 390, 394, 393. I will show.
What
another-
is 394, 390?
My lord, that is the regular sanction building plan 390.
Oh, if they have not done it, then what is to be done?
My lord, that is why, my lord, my prayer is let this plan be cancelled and the
Who
regular.
will cancel the plan?
My lord, the Kolkata Municipal Corporation.
Then why are you here in the writ
No,
proceeding?
because, my lord, since they are not doing it.
Should we direct them to cancel?
My lord, that is their adjudication to be
Sir,
made by
are we supposed to direct them to cancel the plan?
the- we are not asking that.
Then
We are
that is
praying,
why we are
let
asking
it
you,
be
what do you want?
let it be relegated before the municipal authority with the observation whether these kind
Municipal
of
authority has not looked into it.
not doing it. They are doing only one
Please.
thing. They are doing only.
Please don't make such submissions.
Lordship.
Answer the pointed queries
Lordship.
point wise.
Lordship.
Has the Calcutta Municipal Corporation taken any steps in this regard?
They have taken only step. There are some deviations. So far building plan is concerned, they are doing some deviation.
All
as
right.
a result of which 400 subsection 1 notice has been issued for removal of the deviation. Our humble submission.
Then what is the
this
difficulty?
cannot be done under rule 3.2 because this is coming.
Ultimately, therefore we said, ultimately what will be the consequence?
The
If they are doing something which is in the garb of a repair,
yes, madam.
they are making additions.
Yes,
and appropriate steps are being taken for removal of that,
Yes,
then
my
what the writ court is to do?
No, my lord, here, my lord, this particular issue once, my lord,
There
deliberated.
is a magic in the section number or the action is the
My lord,
important.
This action is not sufficient because this construction is illegal because this sanction building plan is not the regular plan.
How many times you will keep submitting the same thing?
No, my lord, excuse, my
Please
lord.
don't repeat repeatedly same thing you are saying.
I apologize.
That we have understood.
I apologize.
Therefore, we asked you,
Kindly.
taking without hearing anyone else, we are taking whatever you say to be a truth.
Yes, sir.
That rather than undertaking repairs, they are going for substantial erection or whatever.
True.
Some action has been taken by the corporation. The ultimate result of the action will be that they will be required to demolish that.
Lordship.
Then what remains?
No, not the entire structure and the leap, my lord, inserted.
What entire structure?
My lord, whole structure they are doing. That is why I am trying to show, my lord, the plan itself. Lordship, kindly.
We are not going to look into the plan. You may try as hard as you may, but we are not going to look into that. That's not the job of the writ court.
Lordship.
Okay, you may try repeatedly. We will not look into it.
No, my lord,
We will record that we refuse to go into that.
True, my lord. That these
So,
particular issue.
The issue is the area which you say is being constructed rather than being repaired.
Lordship.
Ultimately, if it is found that you are correct, has to be demolished.
Lordship.
Appropriate action is in progress.
Lordship.
So, what is the writ court to do?
My lord, kindly see the provision.
Please, when we call on you, yes.
Well, kindly see, my lord, under section 400, subsection 1, what is there? In the event someone exceeds only that.
Therefore, we are asking you.
Yes, my lord.
Whether it is under this section or that section.
Lordship.
Once an action is being taken,
True.
Are you remediless?
No, my lord, that is why, my lord, since KMC is sitting tight.
What tight? They have taken action, you yourself are saying.
Only issued notice under section 400, subsection 1 means, my lord, the construction is rightly going on. Some deviation is there, minor infraction is there. For that, they have issued notice before the special officer building. Our humble submission, my lord, this plan cannot be granted under section rule 32E. My lord, it should be granted under section 390.
So therefore, then, for now, if what we understand is you are not interested with the illegal structure, you want the plan to be cancelled.
At the same time, my lord, because, my lord, that
so for that, writ court should direct sanction plan to be cancelled.
At the same time, my lord,
Sir, we are asking, you are arguing in a writ jurisdiction.
Lordship.
Should we direct for cancelling the sanction plan?
Cancellation for that is to be cancelled by the corporation.
Here we are asking you.
Let it be relegated before the municipal commissioner.
Who is stopping you for going to the municipal commissioner?
We approach municipal commissioner, but
where is your approach?
I'm sure. Lordship will find.
After the order passed under 401, what application you have made before the municipal commission?
No, my lord, before that, my lord.
No, before that we are not concerned. You are saying whatever is being done under 401 is not sufficient.
Yes, my lord.
Then you are required to bring it to the notice of the authority.
The matter is pending before the honorable court.
So we'll release it. You go and do whatever you want.
Before this honorable court, that is why, my lord, no further communication for our.
You go ahead and do it. Who is stopping you?
So, my lord,
You take all the remedies in law. Who is
but
stopping
I'm
you?
showing, my kindly see, my lord, page 90.
We are not interested with prior to 401.
Lordship,
You say 401 action is insufficient.
insufficient.
So you approach the authorities for whatever you think is appropriate.
Authority
Who
is
is
not-
stopping you?
Authority is not doing anything, my lord.
Therefore, what have you done after 401?
But kindly see, my lord.
After 401, don't take us before that.
13 May 2024.
What is the date of 401 order?
I'm coming. My lord, as from the report, my lord, it comes to our knowledge. Lordship will find, my lord, page 62. Page 62, my
Give us
lord,
the
here
date, sir. What
they
is
have
that?
issued 401 notice.
Yes.
By the accordingly, the file has been placed before the higher authority, and as per approval of the higher authority, the case file is now under process under section 400 subsection 1 of the KMC Act. But we are not aware what is the follow-up action taken by the corporation.
So after that, what have you done? Therefore, we are asking
And
you.
we are waiting for, my lord, the letter from the Kolkata Municipal Corporation. Normally, my lord, it is placed before the special officer building. Special officer usually invited, my lord, the person who are making complaint and who is person responsible before the special officer
So
building.
that stage has not come yet.
Not come.
So therefore, we are saying, what?
Yes,
Why
sir.
are you here?
My lord, at the same time, my lord, at the same time, subject.
We are not. See, we don't say what you are saying is wrong.
Lordship, lordship,
We will not say what you are saying is right.
lordship,
At the same time, we will not say what you are saying is right.
lordship, lordship.
But the point is, you have initiated an action. According to you, the outcome is insufficient. It is still in progress. You have all the remedies. Why are you before the writ court?
Only, my lord, 400 subsection 1 notice is not sufficient to redress my grievances.
So
That
you
is not
approach the
sufficient.
authorities. You approach the authorities.
That is not sufficient.
You approach the
For the
authorities.
recalling of the sanction building plan, it is before the municipal commissioner, not before the special
Then
officer building.
you approach
My
the
lord, may I
municipal
be
commission.
permitted, my lord, the similar situation, division bench of this honorable court, my lord, passed order directing, my lord, the municipal authority to relegate, my lord, to, my lord, take appropriate decision. Lordship, kindly see, my lord, this is reported in reference দেবেন তো তারপর আমি যত দিচ্ছি তারপর রেফারেন্স দেবো আপনাকে নিন না লিখে নিন 2002 CHN.
No, we are not going to see the judgment. Show us the provision first.
I am sure. Deeply applies. Deeply applies. Kindly come to, my lord, rule 3(2)(e).
No, what has been done? 401. Show us
40. I'm sure. 40. My lord, 401 is, my lord, order of stoppage of building or works in certain cases. Lordship, kindly come to, my lord, page 62, my lord, they have taken a plea that they have issued notice under section 401. And, my lord, kindly see, my lord, order of stoppage of building of works in certain cases. Where the heritage building or erection of any building or any execution of any work has been commenced or being carried on without or contrary to the sanction referred to in section 396 or in contravention of any condition subject to which such sanction has been accorded or in contravention of the provision of this act or the rules or the regulation made thereunder, the municipal commissioner may, in addition to any other action that may be taken under this act, by order require the person at whose instance the building or the work has been commenced or is being carried on to stop the same forthwith. But in spite of this 401 notice, my lord, they are merely doing work, my lord. Then, my lord, the other provisions are also there. Notwithstanding anything contained elsewhere in this act or any rules or regulation made thereunder, no owner of any building, no person engaged in the construction of any building on behalf of the owner thereof shall allow storage and stagnation of water in the site of construction. This is, my lord, not applicable because of, my lord, to avoid, my lord, the dengue and all these things. B, further construction of the building is carried on in contravention of the provision of clause A, the municipal commissioner may, in addition to any other action that may be taken under this act, or a written order require the person at whose instance such storage of stagnation of water in the site or the construction of the building is made to stop forthwith. My lord, this is also not applicable. My lord, 401 order of stoppage they have issued though work is going on. Along with 401, my lord, they have issued a notice under section 400 within bracket 1. And may I read, my lord? 400 within bracket 1. Where the erection of any building or execution of any work has been commenced or is being carried on or has been completed without or contrary to the sanction referred to in section 396 or in contravention of the provision of this act or the rules and regulation made thereunder, the municipal commissioner may, in addition to any other action, my lord, that may be taken under this act, make an order directing that such erection or work shall be demolished by the person at whose instance the erection of the work has been commenced or is being carried on or has been completed within such period, not being less than 5 days or more than 15 days from the date of a copy of the order of demolition with a brief statement of the reason thereof has been delivered to such person as may be specified in the order. Provided that no order of demolition shall be made unless such person has been given by means of a notice served in such manner as the municipal commissioner may think fit, a reasonable opportunity of showing cause why such order shall not be made. Provided further that where the erection or execution has not been completed, the municipal commissioner may by the same order, by a separate order, whether made at the time of the issue of the notice under the first proviso or at any other time, direct such person to stop the erection of execution until the expiry of that period within which an appeal against the order of demolition, if made, may be preferred under subsection 3. Provided also the municipal commissioner may by order such terms and condition and on payment of such fees as may be prescribed by regulation, condition and payment of such fees, my lord, the minor unauthorized erection or execution of any minor work without sanction, my lord, under this act or minor deviation under the sanction plan or execution of any minor erection or work in contravention of the sanction plan under this act or the rules of the regulation made thereunder as the case may be. My lord, there is a my lord, the what is minor deviation, that is, my lord, in the regulation they have stated. My lord, this particular two provision has been invoked by the Kolkata Corporation. If this honorable court kindly permit me, my lord, to show, my lord, the statute, at the same time the rule 3.2, lordship will find this kind of construction cannot be made, my lord.
Where is your complaint on which the order has been passed?
My lord, the order, page 31, my lord. My lord, the civil court order is there not to do, my lord, the work of.
Where is your complaint on which the order has been passed?
My lord. My lord, kindly come to, my lord, page 28 at the outset, my lord. Page 28.
It is of 8/4/24.
P4, my lord, annexure P4.
8/4/24.
Yes, my lord. 1st March 2024.
First
Page 28. ডিজি কে দেয়া আছে যেটা পেছন থেকে দেখলাম।
We didn't ask you to show us legal notice. Where is the complaint that you filed before the authority?
Page 90, 13 May 2024, addressed to Director General Building.
Page 90.
90.
No, there is some complaint prior to this of April 24. Why are you not showing the April?
This is what the constituted attorney is the owner. Madam, come. Page, my lord, page 64. Page 64. This is the Polish. Address to Director General of Kolkata Municipal Corporation, Chief Executive Officer. comprehensive কি দিয়েছে?
No, sir, that is not the application that is being decided. The application is of 8th April 2024.
And my lord, this is the mail, page 28 is also, my lord.
Where is the application of 8th April 24?
এখানে নেই, paper book এ নেই। My lord, possibly that is not in the record.
Sir, it is there. It is at page 47 of your application. You not included it in the paper book.
Yes, ma'am.
We don't know why.
হ্যাঁ, আপনি কটা কিলো সব কাগজ জানেন?
You are showing us of August, we find an application of April. So which is the earlier one? And you are not including it in the paper book. Why you are suppressing this, we don't know.
No, my lord, with no intention, my lord.
What else is to be gathered from this?
Apologize if this honorable court kindly permit, I can come back, my lord.
Not required. Every day you is being adjourned. Let us see what is there at page 47. Any complaint prior to this?
সে করছে না, একটু আগে কিছু আছে কিনা। আপনার না, এটা can. Well, since we have আমরা দিলাম না কেন? So, my lord, I am grateful to my learned friend, my lord. This is my allegation. The allegation is, my lord, this is not possible under Rule 32E, and that permission has
Still,
been.
you have not answered the queries query.
Lordship.
Which is the earliest application you have made? You are only interested in making submissions.
Lordship.
We are asking you basic facts you are not able to point out.
But since all are. Lord, as per, my lord, the instruction, my lord, as per instruction, this is, my lord, my letter. Address.
So are we to take it that this is the only application, or it will be subject to whatever you may say after 5 minutes?
If this honorable court kindly allow us to come back, my lord, with a
Not
supplementary
prepared.
affidavit, we come.
Unfortunately, you are not prepared.
My lord,
The learned
papers are
advocate
left out,
is
my lord.
unable to assist
This
the
is our
court properly today. List after 1 week. Yes, you have seen 137. So why you did not start? You are for? And you are the person responsible and you are not here when it was called. What is your explanation? We'll look into it. What is, we are asking you, what is your stand? Okay.
Over here, we have been adding without in deep of the book. We have also added the order of the learning triangle, which we are in from the area of response.
All right.
With that we need.
All right.
Now, second issue with regard to the merits of the case, whether we have stated that in paragraph here. From paragraph here, the sequence of events by which the case, the papers were forwarded to us. The various narratives were there by which they were, we were sending the file, we were typing and arguing the principal. With regard to the payment of interest, it entirely the responsibility of the same.
So from what their stand, if we remember correctly from pre-recess session, is that they have forwarded it to you in June, which you have finally processed in October, and the payments have been made in December. These are so in between there is a lot of then they will have to respond to that. Then there is no point in proceeding to that. You have given a copy to both. Yes. An affidavit in opposition is being filed by
Please leave.
Hmm?
Please leave for why I have why I have made party in this writ petition. This is my supplementary writ, mine.
You are filing a supplementary.
This is my lord, I am paying leave.
For?
Why I have made party.
You have said that they may be deleted. And now you are saying why you have pleaded them. What do you want, sir? Before the tribunal, you deleted them. Here you pleaded them. Then you said they may be deleted. Now you are filing an affidavit that they should be. What do you want?
My lord, I am led by Sujit Roth. My lord, please keep it next day, my lord. He has left for, he is unwell and he left for his residence.
But the point is, you want to file a reply to the opposition or not? First, tell us that. Then you do it. Unnecessary adjournment is not desirable. Yes, let the affidavit in opposition is Yes, please read. What is it? So they will rather rely on the gratuity, the provision applying to delayed gratuity. And what is the interest contemplated on delayed payment of gratuity? 6%. No, Gratuity Act will not apply. He is saying that there is some instruction for payment of interest on delayed payment of gratuity. Dues is recovered from whom? You have communicated the dues before December. We are not on that, sir. We are trying to find out. Your DCRB says 1 year prior to retirement, the pension papers have to be complete. 1 month before he retires, it has to be handed over to him. What do you mean has to? If there is no consequence for violating this procedure, what do you mean has to? So therefore, it is open to you to take 10 years. No. Certainly not. As early as possible. Therefore, how do you fix the responsibility? See, that argument he has advanced, but he has forwarded the papers in June. So he was fully functioning. It's not that he was doing nothing. Therefore, 137 says that if there is any delay before the audit officer, they should start the provisional pension. Why have they not done that? If not, who is to be penalized and how? There is no provision in the DCRB or any executive instruction. Responsibility is not to be fixed on anyone.
And these are officers liable for disjection, in particular, thereof, pension generosity shall be held possibly responsible for non-compliance. The procedure referred to followed by is for the payment of pension, any lapse on his part, may apart from making liable for disciplinary action, refer to pay the government staff insurance, the government have to incur via payment of interest or delay.
So ultimately, the person responsible, he will be liable to pay the interest. So we'll see. Let them file the reply.
Item number 24.
I appear for the petition. But I'm praying for
Opposition, sir, opposition is filed.
it will be filed, Lord. I'm praying for 1 week, Lord, to file the
File it. Let us. Reply was not filed before the tribunal. Deputy Master has taken on.
Twenty-five.
Please, Lord.
Let us.
In fact, this was taken up and that was the direction.
Oh, you are required to place the order.
Yes, those were there. If your lordship kindly allows me, I can file with it. I will prepare the supplementary. Let us come back tomorrow because since he is in a difficulty today. Yes.
Next.
Item number 26.
Hmm?
He also informed me what telephone that. Road has-
Not today. Not today. Call the next.
27.
ঠিক আছে। প্রীতম পেয়েছে। The order passed in the earlier way 282.
Hello?
Order passed in way 282.
The earlier order passed on page 154, madam. 154. Order passed by the line tribunal, madam. 11 position 154.
Final order passed in the earlier proceeding. Is this the final order passed in the earlier proceeding?
Madam.
Yes.
My submission is, my lord, that when they crave leave for issuance of fresh charge sheet, but leave was not granted, my lord, in my humble submission, my lord, they cannot issue this same charge sheet. It becomes res judicata. I am relying on the Supreme Court judgment, my lord. Paragraph 15, my lord, kindly see the judgment. Paragraph 15, my lord.
You are raising an issue of res judicata.
My lord. My lord, your lordship, permanent audacity to mention section 11, explanation 5. Where it has been section 11 of the CPC, explanation 5. Kindly see, my lord.
1611.
Section 11, explanation 5. There it has been held that if leave was prayed for, but no order has been passed, it will be deemed that it has been refused. This is my true submission, my lord. When they have craved leave, leave was not granted, they cannot issue the same charge sheet. And secondly, my lord, say under section 11, explanation 5, when they crave leave, but no order has been passed.
It's CPC. Oh, here it is.
Right, before this point.
Yes, explanation 5. What does it say?
Any relief claim in the claim which is not approved, which is not expressly granted, shall be expressly granted by the decree shall be for the purpose of this section be deemed to have been denied, to have been refused.
And this explanation has to be read with the principal provision 11. This is explaining the principal provision. It cannot be read in isolation.
My
So
submission
the
is this.
principal provision is if a issue is finally decided between the parties. What issue was decided between you all? Show us.
Like here, they crave leave that we should be
See,
given
one
liberty.
thing.
That's my submission, madam.
How can
This
it
is
be?
my submission.
Submission is.
When they crave leave before the court, that is my submission. The leave was not granted. They could have approached the higher court, but they want
Leave
their
for
own.
what? They should not have prayed for leave. They have themselves withdrawn it, saying that it is a draft charge sheet. They never issued the final charge.
They have completed the inquiry. My lord, they have completed the inquiry in spite of objection. They have completed the inquiry first, the my lord, provisional final order even. When the matter came up in the final hearing, then they have taken that point. They have objected my objection. They have not refused.
From what we could gather is that they have issued a charge sheet. You have approached the tribunal.
On self-same charge sheet, your lordship kindly come to page 160. Self-same charge sheet. Page 160.
What we have understood is they have issued a charge sheet, charge memo. You have come to the tribunal. You are saying charge memo for some reason or the other, it cannot be sustained. They say it is a draft charge memo. We are sorry. We did not issue the final charge memo. We are withdrawing this and all consequential action is gone. Now, what issue was decided between the parties? What issue? Therefore, we are asking you, what is the issue which was decided? Please tell us.
My submission, ma'am, I'm not clear to your lordship. They crave before the court to give them liberty to issue a fresh charge sheet. Liberty was not granted. Whether they can on their own issue the self-same charge sheet. This is my submission. This is my submission.
That submission, how? Therefore, we are saying your submission we have understood. How that submission is supported by the fifth explanation to section 11. You are relying on a provision which we are finding it difficult. Therefore, we are asking you how that provision will apply. That says in the plaint if a issue is decided and they were not the plaintiffs there and there is no issue decided. That we have understood that they prayed for leave. That leave was explicitly not stated in the order. But how this 11.5 will apply? Therefore, we are asking. The 11.5 appears to be such submission appears to be difficult. There may be other provisions, but we don't know about 11.5. And why a leave is required? Why a leave is required? Leave will be required if the issue is decided. What issue was decided? Therefore, we are asking, what issue was decided? Come to the tribunal's order 282. What is the issue that was decided?
Tribunal did not decide the issue finally. Tribunal only quoted the prayer they have made.
The tribunal only took note of their stand. They said that we have not been able to issue the final charge sheet. By mistake, we have sent the draft charge memo. On that basis, we have. Where is the earlier charge memo?
Page 100.
100.
100.
So the draft, according, is your case that the draft charges and the subsequent charges are one and the same?
Same, identical. Excuse me in repeating. I raised an objection when they issued the charge sheet. There is a draft charge sheet, you cannot proceed with it. But they have completed the charge sheet. They have completed the inquiry. They have passed the final order even, provisional final order. At that stage, when my application came up for hearing, they prayed before the court that they are withdrawing it, they want to fresh charge sheet. This is my submission, man. This is my
Yes.
So far I recollect, kindly, my lord, do not, my lord, there's no need time for the time being. So far I recollect, my lord, before this, my lord, way application, before this way application, the order passed hearing, the earlier way application was filed by him. Now, my lord, that way application, my lord, the state was not the petitioner. The present petitioner, the employee was the petitioner. When the matter was taken up, and my lord, so far I recollect, my lord, he said in that way application, as it has been recorded in the subsequent order of the tribunal, that he said that the draft charges served upon me, since it is not final, so authority cannot proceed with on the same. Now, rightly or wrongly, authority in the meantime proceeded. Inquiry concluded, in the meantime proceeded. That's kindly, my lord, so far the facts, my lord, I can recollect. But eventually, when the matter was taken up before the tribunal, the authority said, very good. When he says that these are draft charges and we cannot proceed the same, whatever we have proceeded with, that can be ignored. So we are withdrawing the same and we are not going to proceed on the basis of their draft charges. That was the submission, and on the basis of that submission, his way application was, my lord, the first way application was disposed of. And disposed of, I think, my lord, that on the basis that it has become, my lord, infectious. Now, when again the charge sheet, my lord, the charges framed and charges, my lord, slapped upon him, and again, my lord, the authority proceeded with in terms of the service rules. Now, the second, my lord, the way application filed and said that it is res judicata. Since, my lord, his point is that number one, res judicata, because once the respondent said that they do not want to proceed with the said draft charges, and since, my lord, no leave was obtained from the tribunal or from the court of law in terms of civil procedure code, and so the authority cannot, my lord, serve the second charges, so cannot, my lord, proceed with the second charges or departmental proceeding. Everything ends therein. Now, my lord, my humble submission to this first, only 2 points for I recollect. That is, the writ petitioner stand is there before the tribunal. Number one, res judicata, and number two, when that first writ petition or tribunal application was disposed of, on the basis of our submission that we do not want to proceed with the draft charge, we did not obtain any leave. Now, my humble submission is this: under the civil procedure code, if it is applied in toto also in the, my lord, the writ jurisdiction, though not in service jurisprudence, everybody we know it, but still, my lord, kindly consider one thing. Concept of res judicata under section 11, what the tribunal has said, rightly said, that this concept of res judicata under section 11 and all its sub clauses, my lord, it is applicable, my lord, to the petitioner who initiated the proceeding, at whose instance the proceeding, my lord, started. It was not the case that proceeding was initiated at my instance. Proceeding initiated by them, we just said that very good, we do not want to proceed with the draft charges, and our submission ended there. And on the basis, the learned, my lord, the tribunal said, then there is nothing to be adjudicated upon. So the petition has become infectious. And the second thing, my lord, the so far that we did not obtain the leave, here also, my lord, order to rule 2 says, as also, my lord, order 23 rule 3. Order to rule 2 or order 23 rule 3.
Yes.
Who will obtain the leave? Who initiated the proceeding? Who started the proceeding? Who is the petitioner or the plaintiff? The authority was neither the petitioner nor the plaintiff nor initiated the proceeding. And, my lord, the language, order to rule 2 read with order 23 also, that if I relinquish my any prayer,
If I waive by any prayer, then for subsequent my lord, the initiation of proceeding, I have to obtain the leave. But unless I initiated the proceeding, unless I drop or relinquish my claim in the my lord the tribunal or the my lord the any my lord the court of law, no question of obtaining any leave.
And what was the prayer in the earlier OA?
Earlier, yes, coming. Earlier, এখানে কি add করেছে? Copy of OA 28 না page? Hmm? 47. Yes, the page 47, that is the prayer in the earlier way. The relief shortfall, an order quashing and setting aside the instrument charge sheet, annexure H.
But this is not OA 282.
And
this is not OA 282. This is OA 307.
307 of 2022 is the my lord the
no, the earlier OA is 282.
282. One five three দেখো তো কি আছে 153 153 is the order passed in OA 2
that we have seen.
Yes, number of the I wait to কি annexure করেছে?
We don't know whether in the earlier OA
Yes.
it was the applicant's case that he cannot be proceeded against because it's a draft charge memo, or it was his case that he cannot be proceeded against by the charge memo and you said it is a draft charge memo. What is the situation?
It has not been
We have gone through your reply in OA 282. That is also on record. But we have not been able to see the application. If it was his case
it was
that he cannot be proceeded against because it's a draft charge memo,
yes.
Then it will be a different consideration. If he had approached the tribunal saying the charge is not maintainable,
My lord, I think, my lord, the contention of the petitioner are recorded in the order itself at page number 153.
but that order is under challenge.
No, that order is not under challenge.
282 order is not under.
282.
Yes, 282 order is not under challenge. That is at page 133.
282 order is at 153.
153, yes. Yes.
Kindly come once again, my lord, at page number 153.
Yes.
My lord, please. Support kindly come to my lord that on consent of council, both the parties matter has been taken up for hearing. The instant application has been filed, initially challenging the memo dated 8th August 24, by which the applicant was charge sheeted. However, during the course of hearing, the departmental representative have produced another communication of 7th September 2015 and submitted. Subsequently, department had realized inadvertently draft article of charges and draft statement of imputation
No,
of
sir, please come to fourth paragraph on the next page. Heard both parties.
Yes, peruse the records. It is noted that the applicant had initially challenged the impugned draft charge sheet dated 8th August 2014 on the ground that the charge sheet was issued in a draft stage.
Correct. So we want to verify this fact from the application.
Well, the application is with them. Let them produce the application.
We have seen that, therefore we are asking, we want to see what was the prayer. What was your prayer in the earlier OA? On what ground? On what ground? Have you stated in the present OA? On what ground the earlier OA was filed? Did you approach this court by complaining that since it is a draft charge memo, they cannot proceed, or you approach this court saying that the charges are not to be proceeded against at all?
Well, I will produce that application, original application.
That will be relevant in view of the submission that you are making.
I will produce. Can allow the supplementary affidavit to produce the proof.
Just bring a copy. Why affidavit is required? You can give him a copy. The because if he has substantially challenged the charge memo, therefore you may have taken leave. If you have not been granted leave, then it may be a different thing. But if his only point was that because it is draft charge memo, it cannot be proceeded against, then the consideration will be different.
My contention would be that, my lord, that subject to correction.
No, we have understood what you are saying, that these provisions he is relying upon will apply only to the plaintiff.
Yes.
Because if he wants to get the benefit of the provision, he has to take the provision as it is.
With regard to settle or withdrawing something, then he has to obtain. Or rule 2, then suppose, my lord, I have so many claims against a particular person, but I filed the plaint only, my lord, not against so many claims, but only 2 or 3 claims.
But you sought,
but without obtaining leave with regard
you sought, it is a case not of leave not being sought. You sought the leave, but it was not granted. You have prayed for leave. It is recorded in the order. That is, oh yes, sir. Come to the last page of the order.
154.
At the top of the last page. And it was opposed by them that no leave should be granted, and leave was not granted. And you never challenged this order.
recorded here that want to give fresh chance to the applicant by way of issuing a fresh charge sheet.
Yes.
Very good, Mala. I shall just make my
Therefore, we want to see what the prayer was. Yes. Yes.
But only thing, Mala, my submission would be that when there was no finality and there is
Yes, you will make your submission. Let us, at least let us verify what was the substantial relief.
just for academic for discussion, that suppose, my lord, I prayed leave, there is no leave granted, or I did not pray leave. Whether, my lord, that would be, my lord, estoppel against the statutory provision or not. Because the statutory provision is that, my lord, I want to proceed under that, my lord, the rules, service rules of 71. So whether that would amount to, my lord, estoppel against the statutory
We will
provision,
consider
my
everything.
rights are stopped when
We will consider everything. Once we know what was the substantial relief, then only we can proceed. Yes.
Item number 28.
My lord, I am for the petitioner. I am led by learned advocate Lakshminath Bhattacharya. Yes, he is Miller, praying for not to demon.
Today.
The petitioner was said that it can be proceeded with the
Item number 30.
Apply for the petitioner. Lord, state file opposition. Lord, I have already, Lord, affirmed this affidavit, and I have already served to the other side, Lord. Lord, this affidavit may kindly taken on record, Lord.
You are filing reply.
My lord.
Opposition is already filed.
Yes, yes. The 30. Reply file.
can you take this matter on?
Not today.
Lord, kindly.
Reply is being taken on record. Matters.
Item number 33.
Item 33, my lord, I appear for the petitioner. My lord, this is the affidavit in reply against the opposition that they have filed.
Who is for the state?
Mr. It's not analogous. My lord, item number 33 and 34 of the same petitioner. If I succeed in 33.
Same petitioner.
Same petitioner. If I succeed in 33, my lord, I succeed in 34. The case is this, my lord, of the petitioner. Petitioner was initially appointed as, my lord, a GDMO, or a General Duty Medical Officer. My lord, at that juncture, my lord, he was asked to file the police verification role for the antecedents that is there. Well, in column 13 of the said PVR, there is a column said whether you have been convicted by a criminal court or you have been charge sheeted in an investigation by the police authority.
Or arrested.
No, arrested is not there in our.
In 13, it is not there.
It was there. Initially, it was there. I accept the law. Now it has been omitted.
No, in one case we saw that question 13 included arrested also.
But now it's not there. Not in this case also, it is not there. So he writes no. Although a criminal case was pending against him, my lord, this was on the month of May when he files the PVR. My lord, in the month of August, the competent court issues notice upon the petitioner to receive the charge memo or the charge sheet. In the month of October, he receives the charge sheet and signs it, my lord, as per the norms. So, my lord, my contention is this: the time when I was filing the PVR, at that point of time, it is not within my knowledge. Although a charge sheet has been filed before the competent criminal court in Baruipur, I was in Midnapur in the month of January. My lord, they took out a proceeding against me, stating that I have suppressed the material fact that I have suppressed the fact that I have written no, although a charge sheet was filed prior to the date of when my PVR was filed. Well, this is the main contention. So that being the reason a proceeding was.
In your reply, how did you make out a case that you had no knowledge about the procedure.
But my lord, there's a court's order I have annexed in my original application and in the leave petition. My lord, the court's order says a direction notice was issued by the court on the month of August that very year 2021. And my lord, ultimately the charge sheet was received by me on the month of October. And my lord, the PVR was filed way back in the month of April. So my lord, I was not in aware. My lord, it's in Baraipur, but you should also take note. My lord, I was working in Mindapur, and this entire PS case was of Baraipur. So my lord, I didn't know. The moment I came to know, my lord, this had
So
happened.
you took a stand that you were not having knowledge about the procedure. What is there? How they have dealt with that?
My lord, they have said no, as because the charge sheet has been filed, whether the stand is also there, as the charge sheet has been already been filed. So you have.
So in absence of accused, the charge sheet was filed.
My lord, it's there. My lord, it's there. My lord, those, my lord, in West Bengal this happens. But this is the norm. I say, my lord, my lord was there for a pretty long time. He has got more experience than any office, my lord. This is normally happens in the district courts. Charge sheets were filed by the police. My lord, notices are issued by the competent judge, asking the petitioners to asking the accused. My lord, yes, my lord, copies have been served.
Copy served.
Yes, my lord, copies have been served. When?
Copy as per the.
My lord,
The accused gets the copy. The accused, he gets the copy of the charge.
I got the copy. I'm not saying. I've got the copy after the PVR was filed in the month of October. Whereas the
No, how you have, so we have understood what you want to say. There are three relevant months: April 21, August 21, and October 20.
I will say 4. January, April, August.
January you submitted the.
They submitted. Police authorities submitted before the court.
Okay, all right. So January is submission of the charge sheet before the court.
Yes, madam.
April you have said no proceeding pending.
Absolutely, madam.
In August it was ultimately served on you.
No, madam. August notice was issued so that I can receive the charge sheet.
So therefore you became aware in August.
August.
In August you became aware as per your case.
Absolutely.
And then in October they have.
In October the learned court handed over me the charge sheet. But this is my case. This was my bone of contention before the inquiring authority that I was not aware. The day when I filed.
So your case is prior to August. I was never aware of the pendency.
This is my contention. But they.
So how they have dealt with this? Can we come to that finding? Their finding.
I'm just coming down.
33 বলছো না
33
blessing 33
33 তোমাদের
so far as item
209 33 মানে 33
so Milord, so far as item 33 is concerned, Milord, I don't represent the state. I believe, Milord, Mr. Basu Malik. Mr. Basu Malik was representing the state in item 33, I believe. On earlier occasion, there was a prayer for filing opposition by the state, Milord.
Yes, his
I
name is
represent item 34.
his name is appearing in the order of 24/9/25. But now I believe he is
He is
not
no
in the.
more in the panel, Lordship.
The advocate of record who has served me the opposition has served me a copy of the reply. I have filed before the Lordship. And 34, the next matter is, my lord.
34, I beg to represent the state.
Again, I appear, my lord, that I say, my lord, the next matter. Again, I qualified an examination of specialist GDMO. Now, my lord, now this time, as because my earlier order, dismissal order is
34
appearing at my face, my lord, your Lordship knows better than me, my lord. If a dismissal order is there, I'm my lord, barred to get any further government appointment. So, my lord, if I succeed in 33,
How can we put the cart before the horse?
yes, my lord, 33 is more important, my lord.
We have to see 33
Yes,
first.
30, that is what I'm saying, my lord. If I succeed in 33, I succeed in 34.
Even if you don't succeed in 33, you may argue 34.
Absolutely not. But then chances will be very limited to me, my lord. Your Lordship knows, my lord.
But even if you succeed in 34, you cannot succeed in 34 unless 33 is.
That's what I'm saying. If I succeed in
Your
33,
dismissal is under rule 8.
absolutely. My lord, if I succeed in 33, then my lord, a shimmer of hope it would be there in 34.
So therefore, how to ensure somebody's appearance? Therefore, we are asking you.
Milord, 33. The GP, Milord, the Office of Learned Government PIDA may be informed about this scenario.
Inform him.
So that he can take some steps to engage somebody. But I beg to
The affidavits have been exchanged.
Yes, my lord.
So it's just a
the
question.
original affidavit has to come from the concerned lawyer because the original has to be filed before your Lordship.
No, let him come then.
That was filed, my lord. Mr. Shayan Ganguly was assisting Mr. Bishop.
Already on record, Lord. I think
This is
so.
on record, my lord. A copy has been served on last year, Lord. I have
Mr.
Shayan Ganguly.
Yes, his name is appearing in the last order also.
Yes, Lord. He filed the
No,
affidavit.
Milord, the affidavit in opposition by the state is on record, Lordship. By the state. When a copy might have been served upon you, but whether the original have been filed before the on-well court or not? I think not, my lord.
Yes, it's not there.
Can't be, lordship, because service affected. But original
Reply is
sign with
there,
the
but it is not there.
law. So as 34 is concerned, I can file on behalf because I represent the state.
So file it.
Lordship,
Take it
34,
on
can
record.
we take our affidavit?
In 33, you, yes, take down in 33.